What connection did you have to these folks in Colorado?
So I had actually looked up on Google.
Found out, because I've been in the dark, that my child was in another state.
Did you consider the long-term effect on baby Thomas as well as Scarlett about separating these two sisters and having them grow up apart versus growing up in the same home?
My goal that these two girls are raised together and that they know each other throughout the entirety of their life.
I'm a parent myself, Miss Thomas, and I'm struggling to understand why you would want to give up your daughter for adoption. That child is...
in terms of what is being appealed and why the court believes that it's necessary.
What if the judge who's granting the interlocutory appeal thinks he made a well-reasoned and informed decision that the Court of Appeals would certainly uphold, but you are saying I need to draw an order that, or a statement for the appeal according to the rules? That is what is said.
Correct.
This is a case, clearly, and you want to respond to any of that? So.
Judge, I would like to respond on the motion for stay, certainly. I don't think a stay is appropriate in this case. This court's already held that it's got jurisdiction. That order is in effect currently, and that order is going to be in effect until and if the Court of Appeals overturns that order, and that's an if that happens. So I don't think a stay is appropriate in this matter. If the court is inclined to grant a stay, I think that stay should only be applicable to baby Thomas that is in Colorado. We have two minor children here. Scarlett Thomas is still with mother in West Virginia. The appeal is solely related to the court's exercise of jurisdiction over baby Thomas. So if the court's inclined to grant a stay, I think that stay should only be applicable to baby Thomas.
And I didn't touch on the stay. I was going to take those as two separate aspects of it because I think those are two separate aspects at this point.
All right. It is this court's opinion that in what I stated before, this is one of the more unusual cases that I've had come before me. This is a case where, based on alleged domestic violence, which I'm understanding from Mr. Kirby, that Mr. Thomas has either pled guilty to or been found guilty of some sort of domestic violence in the past, and that led Mrs. Thomas to relocate to the state of West Virginia with the party's one minor child. But she was pregnant at that time, if I recall correctly, and gave birth to that child and then placed that child for adoption with a couple in Colorado, and that there is a Colorado court exercising jurisdiction over that child, or at least attempting to exercise jurisdiction over that child. Mr. Kirby's argument is that that child, that this court does not have jurisdiction over that child. I am of the opinion that this court, once I assume jurisdiction over the divorce between the parties and any minor children that the parties had, that this court has jurisdiction over any child that is born during the pendency of that divorce action. And for that reason, I am of the opinion that this court is the appropriate venue for all matters concerning the minor children. Mrs. Thomas, through Mr. Kirby, is asking for an interlocutory appeal on the issue of whether or not this court, solely on the issue of whether this court has jurisdiction over the minor child born to Mrs. Thomas and Mr. Thomas, because the DNA test results have shown he is the biological father. And if you are asking for an interlocutory appeal, you understand, if I grant the interlocutory appeal and state the reasons why, it still is up to the Court of Civil Appeal to determine whether they'll even grant that.
Correct.
So a stay as to that child would simply stay this court's exercise of jurisdiction over that child. My concern is whether or not that means that the Colorado court will continue to proceed with the adoption proceedings in the state of Colorado, because if what I don't want to do is grant your request for an interlocutory appeal and then issue a stay order on this court's exercise of jurisdiction over the newborn child that allows the Colorado court to say, hey, we've got jurisdiction because the Tennessee court has stayed that in its own appeal, and that gives them somehow a leg up. That's, I think, would be unfair to Mr. Thomas in that regard. So how do you address that? What is the status of the Colorado proceeding?
The last time, and I've been in communications with the attorney for the petitioners in Colorado at this point for the adoption, they are still going through the jurisdictional argument aspect of things in Colorado as well. The petitioners had submitted their brief on that. I believe that on behalf of father, husband, there was a petition or a brief that had just recently been submitted. There's been no ruling in terms of that in any way. My understanding is that there's not any sort of final hearing that I've been made aware of that is set on that, because they are still going through the base level of, do we have jurisdiction and what are we going to do with that? As far as the concern that the court has, it's a valid concern, obviously. I think there's two things I would say to that. One, we already knew that Colorado was going to do what they were going to do anyways. And this isn't giving up. Sorry. This isn't giving.
Your time is up.
Apparently. This isn't giving up. This is not the court saying that you are giving up jurisdiction under your ruling. This is us simply saying that we need to make sure that this is happening. We are trying to be judicially efficient about it, make sure that there's a uniform body of law, do all the things that are laid out for the reasons that we go under the Trap 9 appeal in the first place. I also believe that it would be appropriate to put into an order to stay that this is, again, not giving up jurisdiction under your order, and that it is not giving free rein to Colorado to move forward, as you still believe that you have jurisdiction pending any ruling by the court.
And your argument that this court lacks jurisdiction over the newborn child has been based on the fact that the Uniform Commercial Code, the Uniform Child Custody Enforcement and Jurisdiction Act says that child never resided in Dixon County, and for that reason, it is not this court's jurisdiction, even though I have asserted jurisdiction over the parties and asserted jurisdiction over their other child. And my response to that has always been that to follow that argument, that it would defeat this court's jurisdiction for any person like the mother to take a child, or if she's pregnant, to leave the state during the pendency of any custody action, and thereby defeat a father's right to have the court that's hearing his divorce action be able to, adjudicate the custody of all of the children, including the one that was born out of state because the mother left, which is exactly what we have.
And I think to respond to that, Your Honor, there's also a separate statute within the UCCJEA. I believe, if I remember right off the top of my head, that is Tennessee Code Annotated 366223, if I'm not mistaken, but please don't hold me to that. But essentially, the statute says that jurisdiction cannot be placed somewhere else if it is done with unclean hands, essentially. That it is done with the intent of trying to go through and
which Mr. Thomas would argue is exactly what your client has done. So.
But it's really not, because we came here before the court. She requested to go there. She requested to do those things. Everyone knew that she was pregnant at that point.
You didn't request to take the newborn child to Colorado and give it up.
That's a separate issue altogether, because my statement is that West Virginia is the home state of the child based on the child being born in West Virginia, and anything that happens in West Virginia after that, that's in West Virginia, and that's a West Virginia problem, and that's something that needs to be sorted out between Colorado and West Virginia.
So that argument, Mr. Thomas would have to then retain counsel here in Dixon County, also retain counsel in West Virginia, and also retain counsel in Colorado, which I think is not what I believe would be the effect that the law has in mind. So I will grant your interlocutory appeal request simply for the basis that this is an unusual situation, and there is the implementation of the Uniform Child Custody and Enforcement Jurisdiction Act brings before the court issues that are not normally in one of these cases, and I'm required to make a finding as to what the issues are. So my suggestion would be that I will draft the order, but I'm going to give you both 10 days to submit to me your proposed issues that you believe require an interlocutory appeal, and then I will draft, using your both suggestions, I'll draft the order that I think is appropriate for it, but I will grant the interlocutory appeal solely as to the newborn child, and I will not grant the stay of the proceedings as to the child that was born during these proceedings, or while they were living here, because I don't think that the Uniform Commercial, why do I keep saying that? That was my least favorite class in law school, was the Uniform Commercial Code. It was the most
We had a teacher that just read from the book the entire time.
Well, I had, when I was in the University of Houston Law School, I know you really want to hear this, we had the guy who actually drafted it. He was like 110 years old, and he was from Harvard, a visiting professor at the University of Houston Law School. And all he did was sit and talk about going to lunch and what over lunch they talked about this provision. 50% of the class dropped it, including myself, dropped it because we were convinced that we weren't learning anything about the Uniform Commercial Code. I have never regretted dropping that class, nor do I ever want to know anything more about it. But the Uniform Child Custody Enforcement Jurisdiction Act, I think, is the key here, and that's where you need to focus what your issues are. So 10 days for each of you to submit the issues that you think need to be adjudicated by an appellate court. I will then draw the order, and if you will also submit an order granting the interlocutory appeal, then I will sign that after I've submitted, at the same time I submit my written statement of the issues.
Understood. And for the record, I had previously filed already an appeal through the Court of Appeals in terms of giving notice. That one's, and I've spoken to counsel about that, it was filed under Trap 3 instead of Trap 9 because I, for lack of a better phrase, fat-fingered it when I was trying to put it through. It's led to the wrong thing, but we're still within there because I've got 10 days after that order is signed.
Right.
So that won't be dismissed. There will be a Trap 9 put in place.
That's
after
between
that.
you and the Court of Civil Appeals.
Exactly. I just want to put it out there on record that one's going away for that purpose.
All right. If you will send those directly to my office, please, and then that will be helpful. If you want to send them to my email address, you can do that if you'd rather do it that way, whatever you want to do. Do you have that email?
I don't know that. I don't do.
I'm going to give it to you, but I'm not going to announce it over.
You don't want to put it
airwaves.
on record for the YouTube watchers?
Yeah. You two are going to have to share. I only have one.
I'll take a picture of it, Judge.
Yeah, I
That's
was going to
fine.
say I'll take a photo of it
And
real quick.
just to be clear for the record, so the court is granting a stay with respect to any proceedings regarding baby Thomas in Colorado. We do have set today an evidentiary hearing on the father's motion to return the minor children to him.
And that's set today?
That is set today. I would ask that that go forward on the basis that the court's still exercising jurisdiction over Scarlett Thomas, the other minor child. The father has witnesses here. We're prepared to move forward on that motion. Also, the motion to reduce his spousal support obligation is set today, and we're prepared to present testimony and evidence in regard to that, as father was paying $1,500.
Well, I'm not staying the proceedings, so as to that child
And if I may, Your Honor, to give the court a little bit about the next steps there, because I don't want to have any surprises. I understand what this court is staying at this point. I may very well file through, if the appeal is accepted through their interlocutory appeal, which I believe that it will be, then I have the opportunity to also ask for a stay through there as far as both children, which we probably will. So I'd ask for time to do that because I have not been able to do it so far. I'll also point out to the court that
let me repeat what you're saying. What exactly are you telling me? That I've granted your stay as to the newborn child. Now you're saying that you may be requesting a stay as to the other child?
correct. My request.
You haven't filed anything such as that yet, right?
I've not been able to because of the fact that we need this stuff from the trial court before I can do anything through the court of appeals. There's not anything there at this time. I did request through the stay here with the trial court for it to be with all children. The reason being for that is because I believe all the evidence that we're talking about here, the purpose for doing this stay is to make sure that we're being as judicially efficient as possible for everyone. And all of the same information we're talking about is essentially going to apply to both children. I'll also say that the motion that's been filed was an ex parte that was denied. And the ex parte relief that was requested was essentially as it related to baby Thomas, that we'll say, which is part of the Colorado. There's nothing there that has any sort of issues for mistreatment or anything along those lines as far as the child that is in my client's care and custody, that she's got the order of protection that is currently there. She has the agreed order that was submitted saying that she went to an undisclosed location for reasonable fear of domestic abuse. I don't believe that any of the situations to do with what's been filed truly relates to the child that is in West Virginia at this point anyways.
Just for the record, it wasn't an ex parte motion for return of the minor children. It was just an emergency motion. Father had found out that the mother had placed the child up for adoption in Colorado. He has not had contact with Scarlett Thomas, the newborn baby Thomas, or the mother in over a year. I understand Mr. Kirby's argument that that's his own doing with respect to the order of protection. The order of protection does not, however, include the minor children. Father has gone over a year without any visitation with these minor children. In his motion for the immediate return of the minor children, he prayed for general relief. The court set this hearing to determine if the father was going to be awarded any parenting time. We're prepared to move forward on an evidentiary hearing. We're getting into a situation, the longer this goes on, the more irreparable harm it's going to create the father's relationship with these minor children.
On the flip side of that, we've got every single statute that says that because the parties cannot communicate things to an order of protection, which was granted and has since been appealed and is still in full force effect at this point in time as an ex parte, and is not set to be heard at an evidentiary hearing stage, then that does not diminish father's ability to come back at a final hearing. The court is not to consider anything for temporary. So I don't think that it's going to be unfairly biased against him. And again, the statements that were there, I believe the only statement that was there as far as the child that's in West Virginia is that father didn't know if she had also put that child up for adoption, and I'm stating on record that she hasn't, and there's no intent to. And last time we were here.
So let's just separate the two, because you keep telling me that those two are separate issues. So let's just disregard the issue about the child in Colorado. We have a father who has not seen his child in West Virginia for over a year. And why would I not allow him to proceed with a hearing today that's been set by notice or set by court order properly? Why would he not be entitled to go forward today with a hearing regarding either an order returning the child or at least establishing some sort of visitation between him and that child? What legal principle would allow you to stop that from happening?
I think the legal principle I would rely on is the fact that, and I think the court's probably not going to agree with me for the request.
I don't think I'm going to agree with you either.
No, but the legal principle I'd be relying on is the fact that everything to do with the state about what is going to be there for, I'm going to say, judicial efficiency. Are you having to expend more time, energy, resources, financial resources?
Well, I'm going to cut you off, Mr. Kirby, because in my opinion, it is manifestly unfair to the father, Mr. Thomas, and I know nothing about him. I mean, I know what's been alleged, and I think this is a case that I set for an evidentiary hearing to determine what is the situation between these parties, what has happened in the past, what are the conditions, like any other child custody case. And I'm going forward with it today. Now, I will pass this case to allow you two to talk about it, but we're going to come up with some sort of a way for Mr. Thomas to have some sort of contact with these children, with this child. It's just a question of under what circumstances, what safeguards and so forth that are going to have to be done. But I have some other matters that hopefully will not take as long, and I expect that we'll have to have a hearing. It'll take some time for your case. So we're going to pass you on the docket and come back to you in a little bit. Your client's on the Zoom. She can stay, and I'll just put her back in the waiting room, and you can talk to her and be prepared for that hearing.
Thank you,
And
Judge.
we'll talk in the meantime.
All right.
Thank you.
Thank you. Now we're back on the Thomas versus Thomas. Yes. You talking about the order? Give it to the clerk's office and they'll put it in my file. I'm here usually every other day or something like that. Are we ready?
We are, Judge.
All right. This is your motion. I believe that your petition for immediate return of the minor child.
That is correct, Judge. There was also a motion set today to reduce spousal support. I would call
Mr. Thomas, I'm going to ask you to come around. Turn that camera on again. It keeps going off. Where's that camera there? Let's see, where do we have we gotta have a microphone set up somewhere. Let's have him go over here. I need that to stay on so that I can, yeah, hit the camera. There you go. Say if you will, Mr. Thomas, raise your right hand. Let's place you under oath.
Grab a seat, Mr. Thomas. Mr. Thomas, would you please state your full name and address for the record?
Michael Jarrell Thomas Jr., 1790 Cedar Creek Road, Van Laird, Tennessee.
And how long have you lived at that address?
About 4 years.
Okay, and do you own or rent that residence?
I own that residence.
Okay, and can you describe for the court the residence? How many bedrooms, bathrooms?
Sure, yes, sir. It's 17-acre farm with,
Pull that microphone up there to you. Ms. Thomas is on Zoom, and so it's important that she be able to hear everything.
it's a farmland with a 25, I think it's 2,500 square feet
If you don't mind just sitting there and keeping it on, so.
log cabin. And so it has 6 bedrooms. Yeah, 6 bedrooms, 2 baths, a basement, a loft in the cabin.
Okay, and is that where you lived with Miss Thomas during the marriage?
Yes, sir, it is.
Okay, does anybody live there presently other than you?
No, sir,
Okay, so you live at that address alone?
I do.
Okay, and do you have rooms set up for the children?
Yes, sir, I do.
Okay, and do you have rooms for both children, both Scarlett and baby Thomas, or just one
Yes,
of the
sir, I do.
children? Judge, permission to pass
You may.
this to, so I've already given these copies to opposing counsel, Your Honor. Mr. Thomas, I'm going to hand you the pictures.
Yes, sir, this is bedroom number 1 that has been set up specifically for Scarlett. And you know, I've not been given the name of baby Thomas. We're referencing her. You know, so this room was set up for these girls, and this is bedroom number 1.
Okay, and do you have clothes? Does it depict in those pictures clothing for the minor children?
Yes, sir. There is some clothing there. There are toys there for the girls, and yes, sir.
Okay, so if the court were to return the children to you, you've got everything set up that you need to take care of the children, is that correct?
Yes, sir. That's
Okay.
correct.
And Judge, I'd move to make that. Did you take those pictures?
I did, yes,
And
sir.
is the condition of the residence in the same condition as it was in those pictures that you took?
The exact precise position that these pictures show, yes, sir.
Judge, I'd move to make those
All right,
collective
if you'll
exhibits.
pass that to the clerk so that she can mark it as an exhibit, please.
No objection for the record.
Guess I should have asked you first, so.
And Mr. Thomas, just to get through some more background information before we kind of get into everything, where are you currently employed?
Currently, I'm employed at Clarksville Granite Company.
Okay, are you the owner of Clarksville Granite Company?
I am the owner, yes, sir.
Okay, and that is an S corporation, is that correct?
It is, yes,
Okay.
sir.
But you are also employed by them, but you are the business owner.
I'm going, for the record, I'm going to show these photographs to Ms. Thomas so that she's able to see what's been marked as Exhibit 1 since she's appearing by Zoom.
Sir.
Sorry. All right, thank you. You may proceed.
And Mr. Thomas, how long have you owned Clarksville Granite Company?
October 1st, 2018. That would put us at 8 years, a little over 8 years now.
Okay, and what do you typically do? What does a day-to-day look like there?
Day-to-day for me looks like I handle pretty much everything at that business. These days I wear most every hat there. We sell granite countertops. We install granite countertops. We manufacture and fabricate granite countertops.
And do you have employees there that work for you?
I did have many employees when I was married. Well, I'm still married, but when Rachel and I were together, I had about 5 5 to 6 employees and 3 subcontract installers. Yes, sir.
Okay. And so do those employees no longer work for you?
They no longer work for me.
Can you tell the court what happened?
Sure. So after the protection order was put into place, I had never suspected. I was caught off guard, so I went back and I started looking in all of my media devices that I owned to find out why my wife was making these false allegations against me. And as I looked through all of these devices, I found messages from many different men. I found pictures in my game cameras all over my farm where men were coming into my house. They were driving into my home. So that's what I found and some of those men worked for me, and many of my employee base, pretty much my entire employee base, was having some type of relations with my wife. And so when I found that out, I lost all of my employees. 2 of those were my sons.
And so you've had a significant reduction in your workforce there at Clarksville Granite, is that correct?
Yes, sir, I did.
Even though that significant reduction has occurred, do you still maintain flexibility with your work schedule?
Yes, sir. Okay. So that we've been able to keep the doors open. I did lose my entire cabinetry division as a result of my wife's actions. So that entire crew I had to let go because of what was going on there. I have one gentleman that works for me now, and he is my subcontract installer, and he also helps me fabricate granite countertops.
So if the court were to return eventually the kids to you, would you be able to facilitate childcare while you're at work? Would you be able to facilitate daycare and things of that nature?
Yes, sir. I have made those arrangements.
And are there specific individuals in mind? Is there someone here today that would be willing to help you with the children?
Yes, sir. There are people here today.
And so kind of getting into a little bit of the backstory, when did you and Rachel marry?
We got married on April the 13th of 2024.
Okay. And what led to the separation?
The separation, I had no idea we were separating. What led to it, it came out of nowhere to me, to be honest. It was one day we were married, and the next day she was gone and making false allegations about me. I was totally blindsided by this.
Okay. And was there a specific point in time when that happened? Did she go out of town for a period of time?
Yes, sir.
Okay. And what happened when she came back?
Sure. So first, Rachel asked me to buy her a ring to recommemorate our marriage. This was 7 days, no, maybe 2 weeks before she made false allegations against me. She asked me to give her $7,000, 5 or 7, to buy a wedding band that she wanted to recommemorate our wedding. And I gladly gave it to her. I was in love with her, you know. I gave her the money, and supposedly she bought the wedding band, and she said she wanted to go to my sister's wedding for a period of about a week, and also some type of girls thing they were doing for about a week, and she left her children, her 13-year-old and 15-year-old teenage child with me, while she went to Atlanta, Georgia, spent 1 week, and during that week, we had some telephone disagreements, and she had mentioned that she was pregnant at the time, and that she wanted to have put the baby up for adoption. And part of the argument that we had while she was there was that I did not agree to the adoption. I in fact expressed to her that I would prefer to divorce her than to adopt our child out. She did not want the child. She felt like her hands were full, and she did not want to take the responsibility of that baby. And so I several times on the phone, probably have messages. I conveyed to her that I would prefer to divorce her than have an abortion. So the night that she returned from this Atlanta trip is the night that she hit the record button on her phone, sat down, started an argument with me. The next day I woke up and the cops were there telling me I had to leave my home and that she had made false allegations against me.
And so can you explain to the court what your relationship was? How old is Scarlett, first of all?
Right now, Scarlett's 14, 15 months old.
Okay.
And,
And how long has it been since you've seen Scarlett?
I've not seen Scarlett for last September.
This past September?
Yes,
okay.
sir.
And what was your relationship like with Scarlett prior to Miss Thomas leaving?
It was a beautiful relationship that she had become my whole drive in life. I was presented with this little angel every morning when I woke up. I would spend about an hour and a half with her before I went to work while Rachel prepared for her days. I would take the baby and take care of her during that time before I left for work. When I got home from work, Scarlett was given to me because Rachel had had a long day, taking care of her. By the time I had gotten home from work, every day without hesitation, she was thrust upon me, take the baby, and I would rush home from work to take that baby. I was in love with that baby. I still am, but I've had to push it all in the back and not think about it because it hurts so much so that was our relationship. Like I took total care of the baby while I was at the house.
Did you provide for her? Did you provide food, clothing?
Yes, sir.
Medical care? Did you ever take her to the doctor?
As far as the doctor, I think we did go to a doctor visit one time. Yes, sir.
And she had a primary care physician when she was here?
She did. We had set her up with one of my pastor friends who is a physician's assistant and has a practice in Clarksville. His name is Cliff Signer.
And so you had mentioned a moment ago about the adoption and being made aware of the adoption. Did you take Miss Thomas seriously when she had mentioned sending this newborn child or setting this newborn child up for adoption?
I didn't really think it was that serious. No, especially when I told her that I would divorce you. That was my way of saying we're not doing this.
Did you ever tell her if she signed divorce paperwork, you would sign adoption paperwork?
I may have said those words in a message to say to her, if this happens, we're getting divorced. The only way this is happening is if we get divorced.
Did she ever consult any adoption agencies that you're aware of?
So I'm not aware that she consulted any
Were you ever a party to
agencies.
any of those conversations? Did you ever consult with any adoption agencies?
Absolutely not.
Okay.
This whole adoption was, I did see in an email where she was reaching out in social groups on Facebook where she was soliciting Facebook groups to find a person to adopt this child. And I think I sent you those emails where she had, this was after the divorce was filed. We were no contact. But
So after that order of protection had been entered, after the divorce had been filed, you had no contact with her about the adoption?
That's correct, sir.
Okay. She didn't tell you she was about to place the child up for adoption? She didn't tell you that she was signing a termination of her parental rights?
I had no idea any of those things were happening. I was in the dark as to
And you only found
any
out that it
information.
occurred after you'd been served with that
Yes,
petition,
sir.
is that correct?
I had suspected, that she was considering that, but I had no idea.
And so it's been represented to the court that you have been convicted of domestic assault. Now, let's go back. You had described earlier an incident in September. Is that the incident you're referring to?
Yes, sir.
Okay. And what plea did you enter? Do you
Well,
recall?
I don't recall the name of the plea, but I do recall that the attorney advised me that when after the judge read the plea off and I agreed to it, that to be sure that I say not guilty that I'm not guilty of this. I don't remember the name of it, but it was, when the judge said, "How do you plea?" It was very clear that my attorney made it to me to say the word, "You plead not guilty."
If the court records reflect you entered into a no contest plea to a simple assault and a violation of an order of protection, does that sound accurate?
Yes, sir.
Okay. And you were, as a result of that, you were placed on probation for a year, is that correct?
Yes, sir.
And are you currently still on probation?
Yes, sir.
Have you had any issues with probation?
No, sir. I
Have you failed
not.
to report to probation?
No, sir. I
Have you had
not.
any probation violations filed against you?
No, sir. I
Have you
not.
failed any drug screens administered by probation?
No, sir. I have not.
Have you paid your probation fees and court costs?
Yes, sir. I have.
And so as we sit here today, there are no violations of your probation, correct?
That is correct.
Have you been charged with any new criminal offenses?
No, sir.
And why did you enter into a no contest plea instead of going to trial?
Well, number one, I was not guilty of the charges, and my attorney advised me that was the best thing I could do.
What do you want the court to understand about how you've responded to everything that's happened over the last year in your life?
Wow. I'd like the court to know that on September the 21st, my entire world was taken away from me based on a false allegation. My entire world was destroyed. I was in love with my family. I was not a perfect person. I showed up for my family every day, 6 o'clock without fail. I was in that house with that family every day, trying to love on them. 7 o'clock every morning, I went to work and I come home. And on September the 21st, I was hit with, I was destroyed, devastated, and appalled that these allegations were made about me by my wife, whom I loved. And I didn't know that there was many other men involved in this until the judge affirmed the order of protection. When that day happened, I was even more utterly destroyed because an affirmation had been made about something that I was in no way guilty of. And so I went through several weeks of a very dark spell at that time. And in that time, I had to sit down and learn all the things about what had happened, who was all involved. And so for the following month, it was revealed to me through, looking through it, looking at everything closer. I wasn't looking close in our relationship. I wasn't paying attention during our relationship. Maybe I was in a fog or something, but when I started paying attention and checking my game cameras at home that I had throughout the woods and in the driveway, and I found out what was truly going on.
And so were there things, you had mentioned earlier, you had a very close relationship with Scarlett. You treated Scarlett as your own. And ultimately, you ended up questioning whether you were Scarlett's biological father. Were there things that made you question after the fact if you were Scarlett's biological father?
Yes,
Okay,
sir.
and what were those things that you had discovered?
Those things were the text messages that I had found in my phone that my wife had made with my son. The messages I had sent to my wife in reference to her having relations with my two sons, 21 and 22-year-old, and also their friend Nathan, who's about 22 years old. And so when I received text message confirmation from her, when I sent her a message asking her about this, her response was yeah, it happened. And so
Let me make sure I'm understanding you. Are you saying that your wife, Ms. Thomas, has confirmed to you that she had sexual relations with your two adult sons and a friend of theirs?
That is correct, sir.
You have proof of that?
I have it in a text message in my phone in my car.
Did she explicitly affirm that she had sexual relations with them, or did she just not deny it, Mr. Thomas?
She did not deny it. She made a response to a message. I said in the message, so you've basically been sleeping around with my sons, and her response was, you've been sleeping around with my band or my sons, and her response was, they were your sons first, or they were your band first. That's the exact context.
But she never made any explicit admission that that was the case, correct?
To me, that's pretty explicit. She was explicitly said, yeah, it just in a different way, she confirmed it. That's one. There are other confirmations as well, and pictures and things that I have.
And so if the court were to award you temporary custody or any form of parenting time with Scarlett today, are you willing to co-parent with Mrs. Thomas?
Yes, sir, I am.
Okay. And what is your position on keeping the two children together as siblings?
That is my goal, that these two girls are raised together and that they know each other throughout the entirety of their life.
Okay. And are you willing to participate in anything this court asks you to do to have visitation with your child right now, with Scarlett right now, to be determined with baby Thomas? Or are you willing to jump through any hoop that this court has? Are you willing to have supervised visits starting out? Are you willing to do anything to have parenting time with your children?
The door is closed currently, sir. I have no children at all. My life was built around my sons, my children. All that was taken from me in this divorce. So to answer your question, yes, I'm willing to do anything.
And why is it that you want custody of your children?
My children are why I get up and go to work every day. They're the reason that I function. My children are the reason that I live. And my reason to live was taken away from me with this, all of my sons, my baby girls, all of that. So I've lost I had to find a new reason to live because my children were taken from me.
And why do you feel that Scarlett is subject to an immediate threat of irreparable harm while in Ms. Thomas's care?
I've learned that Ms. Thomas has so the things that occurred with my boys, they occurred with other people, other men, and it's hard for me to even think about. I keep all this back here, but all of those things were occurring.
Well, specifically, she didn't consult with you about the adoption before Blaze. I'll rephrase.
I'm sorry.
Leading. He's getting.
Sustained, don't lead the witness.
I believe you previously testified. Is it true you previously testified that she did not consult you before giving baby Thomas up for adoption?
That is true.
Okay. And are you in fear? Does that create any kind of fear for you due to or with respect to her parenting responsibilities of Scarlett?
Absolutely.
Why?
Because that family that she sent our child to live with, we know nothing about those people. They've had our child now for several months, and we don't know anything about them.
You've never met them.
I've never met them.
You don't know them.
Don't know them. Not allowed to contact them. Not allowed to inquire who they are, anything about them. Moreover, Ms. Thomas was seeking to aggressively release this child into somebody's care. She was not looking to aggressively research their background, find out who they are.
And you are currently under a temporary support order by this court.
Yes, sir.
Okay. How much a month do you pay to Ms. Thomas?
$1,500 a month.
Okay. Is that just the support order, or does that include everything you pay on her behalf?
So I also currently pay for a 2024 Ford Expedition payment.
How much is that a month?
That payment is over $1,300 a month, less than 14, and the insurance on that vehicle is about probably $300 a month.
You filed a copy of your income and expense statement with the court yesterday, is that correct?
Yes, sir.
Okay, and I'm going to pass you up, Judge, permission to pass. Now, you are paid a salary by your company, is that correct?
Yes, sir, I am.
Okay, and how much are you paid? Is that a true and accurate reflection of your income and expenses?
Yes, sir, it is.
Okay, so you are operating at a deficit of $701.08, and that is before the spousal support payment is paid, before the car insurance is paid, and before the car payment is paid. Is that correct?
That is correct.
Okay, so are you having to rely on your savings or your business's savings to pay those things? How are you paying, how are you affording to pay for those things?
Sure, it's with my savings account.
Okay, and what was the balance of your savings account at the time this proceeding started?
So my savings account is, been around $50,000,
Okay, and what's the balance of it now?
probably 40,000.
And so are you asking the court to reduce the temporary support payment?
I am asking the court to please reduce this support payment.
Okay.
Yes, sir.
And there was a previous hearing that was held. You had different counsel at the time, but is it your claim you did not have notice of that temporary support hearing?
That is correct. I did not know
So to
that.
your understanding, the court didn't hear any testimony from you or any proof from you regarding your ability to pay any type of temporary support?
That's correct.
Okay. And so what are you able to provide any type of temporary support to Ms. Thomas?
Yes, sir. I am able to provide temporary support. I prefer to call it child support, as she has Scarlett, but whatever we want to call
And
it.
just to be clear, that order classified it as temporary support and child support. So is there an
Oh,
amount
did
that
it?
you can afford to pay, Ms. Thomas? And what would that amount be?
You know, honestly, I probably should have thought about that before I answer that question. I know what I make, and I would request that whatever the state guidelines are based on what I make, I would feel comfortable paying that.
No further questions, Judge.
Kirby, you may cross-examine.
Thank you, Your Honor. Morning, Mr. Thomas.
Good morning, sir.
My name's Anthony Kirby. I represent your spouse, Miss Rachel Thomas, okay?
Good to meet you, sir.
Good to meet you. I've got just a few things to question you about. I'm going to start
Hold on a
on the...
second. Was that made an exhibit, his income and expense statement?
I'll move to make it.
Let's make that the next exhibit in order.
For the record, Your Honor, no objection.
Thank you, Mr. Kirby. One of these times I'll get around to asking you about it before.
You're perfectly fine, Your Honor. I was in a trial, 2-day hearing the other day, and a counsel forgot my entire name while they were doing closing arguments. So I'm used to it at this point. Ms. Thomas, I got a couple questions for you, okay? So I'm looking at your income and expense affidavit, and I apologize. I was trying to write down things, but I did not get this down. What is your salary that you get paid?
So I get a paycheck every week of about $800.
Okay. And so extrapolating that out, what is your salary per year?
So let me give him back his income and expense statement then, if he's going to be questioned.
Yeah.
Did you say that there was a copy of that in the file?
There's
Let me take this apart again. All right, go ahead, I'm sorry.
And so if you get paid $800, is it fair enough to say that you're paying yourself through the business approximately $41,000 to $42,000 a year?
Yes, sir, that's correct.
Okay. And this is a business you own, right?
It is.
Sole proprietorship?
No, it's an S corp.
S Corp?
Yes, sir.
Are you set up as the sole managing member of the S Corp?
Yes, sir, I am.
Okay. So in terms of who gets to pay who, you get to make that decision top to bottom, right?
Yes,
You don't run anything else past anyone else as far as your income is concerned, correct?
that's correct.
Okay, and I see on your income and expense statement that it says your business pays telephone, car payment, and car insurance. Is that right?
That's correct.
Okay, so you use, like most people do that have a corporation or any sort of business, you use your business profits to be able to pay some of the things for your personal life that you get to use on a daily basis too, right?
Absolutely not.
No?
No.
Who pays for your car?
So my car, so my personal life, I have a motorcycle that I drive. I have other vehicles. This particular car that you're talking about is my work vehicles.
Okay, so do you owe anything on any of your other vehicles?
So I owe money on the vehicle that Rachel drives.
Okay, what about any of the other vehicles that you had? You said you had multiple vehicles in your possession.
That's right. That's what I owe. My motorcycle is paid off, and I owe what Rachel is driving.
What other vehicles do you have?
I have a 25 Mustang.
And you bought that right after y'all separated, right?
That's correct.
And you actually paid cash for that?
I did.
Okay, so
No, stop. I did not pay cash for that. That's finance. I'm sorry.
that's finance,
It
but
is
it's paid off
financed.
at this point, right?
No, it's not paid off.
You got money owed on that?
Yes, I do.
Who's paying for that? Your business, right?
I pay for that.
You pay for that
Yes,
through your business?
that's right.
Okay, so that's what I'm getting to, right?
Okay.
You pay for your stuff through your business, right?
This is a work vehicle.
It's your 2025 Mustang for a granite company is a work vehicle.
Absolutely.
You can haul granite on your 2025
I
Mustang?
drive that car to every measurement job, to every meeting, to work and back every day.
Understood.
This car does not sit in my driveway, and I don't take it to car meets. I drive it to work. I drive it all around to measure jobs every day.
Understood. And so as far as that car is concerned, you're actually adding on to that vehicle as well, right? You've bought a bunch of parts for it to add on to it, make it faster, make it more cool, right?
No,
No?
I'm not. Let me see. I did put a new muffler on it. Yes,
Okay.
you're right.
Did the business pay for that too?
It did.
Was that necessary for your business, or that's just something you want to put on the
It's
vehicle?
regardless. That's not a question, whether it's necessary for business or not. Whenever I purchase a saw for my granite company, I'm allowed to purchase blades for that saw that increase its productivity.
Understood. Let's talk about your business account then. How
Sure.
much do you have in your business account?
Currently around $100,000.
Okay, so you get to pay through your business account anything that you deem necessary for your life that you think benefits your business, right?
If it's business related, yes,
Okay. And you say that you had $100,000 in there right now, right?
that's correct.
Okay. Previously, you had a lot more than that, right?
That's correct.
Okay. I'm going to pass up a document to you.
Sure.
You recognize this statement, right?
Yeah, the one that was stolen from my vehicle when she stole my truck, yes.
Get to that in a minute, I guess, then. When it comes to this is the business account for the Clarksville Granite Inc., right?
Looks like that's what this is, yes.
And just to make sure, during y'all's relationship, marriage, after the separation, my client has no access to any of these funds, right?
No,
Okay. And at that point in time, you had, this shows $252,101.50 in your business account, right?
that's correct.
Okay. And that was right before y'all's separation statement ending July 31st, 2025.
That's correct.
Okay. Make that the next exhibit, if I may, Your Honor.
Exhibit 3.
So you have $40,000 in your savings right now, personal savings.
Yes, sir.
You, by your testimony here, have a little over $100,000 in your business account.
That's correct.
And at some point within the past year, essentially, you had over $250,000 in your business account, right?
That's correct.
Okay. And you can't afford to pay $1,500 a month?
That's correct. I cannot
Afford it.
afford it.
Okay. If I do $100,000 divided by 15, that's 66 months at that point, right? Does that sound about right?
Please explain a little closer. I'm trying to follow where you're going with this.
You have $140,000 to your disposal,
Okay.
correct?
That's right.
Okay. And that's not including anything for your checking account. What do you have in your checking account?
Maybe $5,000.
Okay. So we'll discount that for argument of this, okay?
Okay.
So you've got $140,000 at your disposal as we sit here today. If you had no other money go into your business account, you could pay $1,500 for the next 93 months. That seem about right?
No, it does not, because I have business expenses that by far exceed any of that revolve every single week. The $250,000 that you mentioned, there was a employee cost every week of about $9,000, so 9, 18, 24, 36. You're looking at a $40,000 revolving fee on top of granite materials, gas. $60,000, $70,000 a month is where when we were together, that's how it was revolving, and this was an S-Corp account. When I lived with her, all of our expenses were also paid from my savings account, not from this business. The entire time that I lived with Ms. Thomas, I was given a paycheck from my business. That has not changed.
Pass you up another document as well. You recognize these statements?
Yes, sir, I do.
Okay, these are statements that were being deposited into your business account, correct?
Yes, sir.
On one of them was $45,437.38, right?
That's correct.
One of them was $2,270.61, right?
That's correct.
And one of them was $16,458.23, right?
That's absolutely correct.
Okay, and these aren't all of the things that you're making. These are just showing that you get significant amounts of money paid to your business that you get to continue to deposit into that $100,000 account that you get to use, correct?
Significant amount of money come out of that account. You're only addressing what's going in.
May that the next collective exhibit, if I may, Your Honor. You and my client have or maybe had a joint account. I don't know if it's still open or not. Is that a correct statement?
It is.
Okay. And did you move a bunch of money out of that account?
Over the past year, I've moved money through that account, in and out of it the entire time. Yes, sir.
Okay. At one point, did you leave 53 cents in that account after a month?
It's very possible. Yes, sir.
This was right before y'all's separation, right?
I'm sure I drained that account once I found out everything that was going on. Yes,
So
absolutely.
you took it upon yourself, you made a unilateral decision to go ahead and drain that account, right?
How much money was in there when I drained it? Because we only kept like maybe $1,000 in this account revolving at all times.
Well, you essentially, this was the only account in which my client had any access to funds, correct?
Okay.
Is that correct?
So she stole money also.
Well,
you
this,
know,
this isn't my question, sir.
Right.
I'm going to ask the questions. You can answer the
Sure.
questions. Y'all had a joint account, correct?
Yes, we did.
My client had access to the joint account to use funds to purchase things throughout the day, correct?
That's correct.
Okay. She did not have access to your savings account that has $40,000 in it, correct?
She had her own bank account also,
She
apart from this account also.
She did not have access to the $5,000 in your checking account, correct?
But that account is this account.
And she
Right.
didn't have so now you've built this back up to 5,000 is what you're saying.
That's what I'm saying, yes.
And she didn't have access to the $252,000 that was in your business account, right?
Did she have access to it? Let me think about that answer for a moment, please.
I think you've already said that she didn't.
No, she's had well, here's something I forgot, okay? I've noticed that maybe she didn't have access to this, but she gained access to it several times, and we'll get into that later.
Okay. As far as this, though, it's your testimony that this typically had $1,000 to $2,000 in it at that point,
Which account are you referring to?
the one that I just passed up for you.
Yes, sir.
Okay.
That's about right.
And now it's at about $5,000, correct? Okay.
That's correct.
And my client doesn't have access to that account as we sit here today. Is that a fair enough statement?
That's correct.
Okay. Because you removed her from that account, right?
Yeah, that's right.
Okay. And when you find out that there was things going on based on your statements and your testimony here today, you drained this account and left with 53 cents in that account, correct?
That's correct.
Okay. Made that the next exhibit, if I may, Your Honor. My client was essentially solely reliant on you for income during y'all's marriage and relationship, right?
That is not true.
No? You were the primary breadwinner for the home. That's got to be true, right?
I was with her for 1 year. She had child support from 2 other men.
Okay. So she had child support from 2 other men at that point for children that she still has in her care and custody, right?
That's correct. That
Okay.
she never used. She stored it away in a secret account somewhere nobody knew about, nobody cared.
Okay. And so in terms of money that was coming into the home, you were the one providing money coming into the home for the 2 of you, right?
For the year and few months that we were together, we knew each other, yes, sir.
Okay. And you want the court to now say that you shouldn't have to pay her the $1,500, you shouldn't have to pay for her insurance, you shouldn't have to pay for her vehicle. You should just calculate out whatever's on the child support worksheet based on the $800 a month you've decided to give yourself unilaterally through your business, right?
That's exactly right, yes, sir.
Okay.
Not $800 a month.
$800 a week, I apologize. That was
That's
my
right.
bad, Your Honor.
Yes, sir.
Thank you. $800 a week.
Yes, sir.
Okay. Another point of this, you really just don't like my client, right?
I love her and I have forgiven her. There's no don't like about it. I was in love with her and my pastor has taught me to forgive her and I still love her
When was that forgiveness taking place?
over the past several months.
Okay, so when you paid your $1,500 for support on July 1st and you put into the memo line that you were paying her for telling lies and stealing, was that forgiveness?
I don't know what that was.
You did that though, right?
That's what she did. So that's what it was for.
But that's forgiveness in your book, right?
I have forgiven her.
Okay. And in terms of the aspect of this hearing that happened previously, right? Let's go through that for just a moment. You were duly represented at that point. You had counsel.
What hearing are we referring to, sir?
When the current support was ordered, you had counsel at that point, correct?
At that hearing, my counsel had submitted his documentation to be removed as counsel.
Okay.
So that's when her counsel stepped in and had this support hearing made. I
And
was
so
not
it's-
aware that I needed to be present at that. I was not told I needed to go. I knew my attorney was removing himself. I was not prepared to argue that, so I didn't go to that hearing because of that reason.
And you just decided not to go, but you knew that the motion was on the docket, right?
I knew my attorney was removing himself from my case.
And you knew that the motion for support was on the docket
No,
as well.
absolutely not.
Well, you just
I-
said that you weren't
I did
prepared
not
to.
know that hearing was that subject matter was being heard. All I knew, as God is my witness, is that my attorney was removing himself from my case.
Let me. And if your attorney came into this court and represented that he had spoken to you and informed you of that motion, he would be lying to the court?
Absolutely, sir.
As an officer of the court, you're
No,
saying
no,
that
he
he's
told me
lying to
about
the court?
the motion to remove him from my case. He did, and in fact, we never spoke about that. I got an email that said that on this date, I read the motion. It said he was removing himself on this date. And in my mind, I thought, okay, he's removing himself from the case. I'm not arguing that. It doesn't say here, Michael, you need to be here on this date. I just seen I never even received a subpoena for the date. I just seen the motion is what he emailed me. So it didn't click in my little simple mind that I needed to be in court that day. I wasn't arguing it. You know, I knew I had to find another attorney is what my little mind thought.
Understood. Let's go with your other motion then for just a moment, okay? As far as this emergency motion that you filed. First off, you had told multiple people that these children weren't your children, right?
I've never told anybody that. I said there was a question after I found out about some things.
Some things that you inferred through my client's response based on your testimony. There was never any sort of admittance to anything on that side of things, correct?
She has admitted to it. My sons have admitted to it, yes.
Okay, your sons aren't here today, right?
That's correct.
And you haven't presented any sort of actual proof that she's admitted to it, right?
I was not advised that that was something I needed to prepare today.
So that was something, you had issues with your previous counsel, now you've got issues with this counsel, not advising you of certain things.
I
That's
have
your
no
testimony?
issues with my counsel.
Okay.
We were here to address something different today. We weren't here to address those ugly things. We're here to try to help me gain a little time with my children.
And that's what you're asking for at this point, right? Is a little time with your children.
I'm asking for full custody of my children.
Well, that's far different than a little time with your child. So
Well-
which one is it?
Pardon me for misspeaking. It's full custody is what I'm asking for. And to be honest, the best word is anything,
Well, that's again also far different than full custody.
right? Because right now I have nothing, sir.
And you've got nothing because there was an order of protection that was taken out, right?
Yes, sir.
And you were served with that order of protection.
Yes, sir.
And you didn't show up to that order of protection, did you?
I'm sorry, I believe I attended all court dates.
Did you?
Yes.
Okay. And there was a
Believe I did.
hearing after that.
I'm not aware of a hearing that I missed, sir.
But the order of protection was put in place, right?
Yes, it was.
Okay, and there was an agreed order at some point put in through this court saying that my client could go to an undisclosed location based on the domestic violence that had occurred within y'all's marriage, right?
Based on the alleged domestic violence, yes, sir.
Okay. And you were arrested for domestic violence, correct?
I think they arrested me for something else. It was violation of the order is what I was arrested. I was never arrested for domestic violence.
You've been arrested for aggravated assault many times in your past, though, right?
Not that I recall, sir.
You've been found guilty of aggravated assault as a felony previously, right?
Not that I recall, sir. I don't remember that.
Hold on just a second. I'm sorry.
Convictions, I don't know when they're from, what county. This, if they don't.
Well, he can only be cross-examined about what he may have been convicted of, not what he's been charged with, because that's the rule of evidence is that you can cross-examine a witness regarding a prior conviction of a felony if that, or a misdemeanor involving moral turpitude. So sustain the objection as to the form of the question at this point.
I'll rephrase at this point. You were previously convicted and put on probation in Georgia, right?
13 years ago.
Okay.
And if it's over 10 years, it's not admissible anyway.
I'll move past. You were previously, do you still have a pending criminal charge for aggravated assault in, I believe it was South Carolina?
Absolutely not.
You were arrested on that, though, right? When was that taken care of?
So that was taken care of 2 months ago, and the district attorney in that case called me.
I'm not going to ask you what the district attorney says. You can't testify to what anyone else says. Do you have anything here with you today that says that that was dismissed or taken care of in some way?
No.
Okay. And as far as your emergency motion that you filed.
That was over 10 years, by the way. Also.
You don't have anything in terms of, the charge wasn't over 10 years ago. You just got arrested on it recently.
Yes,
but
it was. It was over 10 years, sir.
It just got resolved here recently, though, right?
Right. It was
By your
thrown-
testimony?
It was thrown out.
Okay. As far as the aspect of what you're asking for here, your motion deals entirely with who we've been referring to as baby girl Thomas and this adoption aspect of things, correct?
Can you repeat the question?
Your motion deals entirely with who we've been calling baby girl Thomas and the adoption aspects of
What
things,
motion
correct?
are you referring to? Because there's many of them here.
Sustained.
You filed a motion for emergency custody, emergency return of the minor children, right?
Yes, I believe
And that
we
was
have.
based on the fact that you found out that there's an adoption that's pending in Colorado as it relates to baby girl Thomas, correct?
So I filed the motion for custody of that child when I was presented with legal documentation that said she had signed away her rights to that child, and this new family was asking me to sign away my rights. It was at that moment that I found out, because I've been in the dark, that my child was in another state. It was at that moment that I learned I have to take legal action right now. So to answer your question, yes, sir, that's whenever I filed the motion.
Okay. And then as far as Scarlett is concerned, you have absolutely no claim that Scarlett is being mistreated in any way, correct?
I have no claim because I've had no contact. I don't know. I do know the life that was lived when she was here. And
Okay. And just to be clear, you haven't presented anything as far as photographs or videos or text messages or to corroborate anything that you've testified to about these alleged affairs that seem to be the brunt of your concern with mother, right? None of that's been introduced today.
it has not, no, sir.
Okay. And so as it relates to Scarlett, what's Scarlett's date of birth?
Scarlett?
Yes.
Scarlett was born on March 17th, 2024.
2024?
2025, I'm sorry.
Okay. And so At this point, y'all have been separated since September of 2025, right?
Yes,
And so this child, it's fair to say, doesn't know you. Is that a fair enough statement?
that's not fair at all. I spent every day with that baby for the first 6.5, 7 months of her life. And I don't know about you, but for 7 months that you spend with somebody, would you say
You can't
5
ask
months?
him questions, Mr.
Sorry, sir.
Thomas. You just answer his, please.
Okay, sorry, I apologize.
During that period of time where the child was in your home, did you have issues of anger?
No, sir.
You didn't yell, you didn't cuss at other people in the home or other children in the home?
I'm sure at times I raised my voice, yes, sir.
You raised your voice at times, right?
Yes, sir.
Did you ever go so far that you ripped apart an oven so that it was not useful?
I don't recall ripping apart an oven that was, no, I know that I did not. So to answer your question, no.
I'm going to play a video, if I may, Your Honor, and a best way to do this that I know of would be to play it and stand over here. Or,
You can play it through the network if you know how to plug it in. We've got bailiffs here who are fairly adept at that. We have a USB cord there on the,
I can log into the video and share my screen on the video.
whatever you want to do. If you're going to show him, I assume you want me to see it at some point too.
Yes.
Then you show him and then you can show me, whatever you want to do. I don't care. We're approaching the noon hour and we'll be adjourning for lunch, or recessing for lunch. So what I would say is let's get as much ground covered as we can, so.
And yes, Your Honor, and I've got a final hearing in Montgomery County that's been pushed to 1 o'clock at this point, so I've got that issue as well. So let me try to play this for him, and then I'll play it for you because that'll be the quickest way of doing it. It's a short video. For the record, I have shown this video to opposing counsel. I approached to.
Well, let me ask you a question. If you are supposed to be at a final hearing at 1 o'clock, exactly, we're not going to be finished with this hearing at that point.
I would hope we would be. I'm almost done with this aspect of it. I guess we're not going to be, but we're calling other witnesses.
But I was expecting that it would be more than just Mr. Thomas. All right, go forward with this. We'll deal with that.
I would make an objection to this video. I don't think my client's present in the video. You can see
What is the video of
the
Mr.
video that has a foundation has been provided.
What is the video of Mr. Kirby?
Video is of Mr. Thomas, and you can clearly see, not see, but you can clearly hear his voice as far as what is being said through that. It is a early morning in which he is, I'm going to say, belligerent, talking to other children within the home. This would have been after the birth of the Scarlett. The video was taken by my client, but I believe that he can easily testify and identify his own voice.
Show him the video and he'll be asked if whether or not he can authenticate it. If he cannot authenticate it, then it cannot be introduced.
I'll play it through my client at that point. May I stand over here? I'll stop it there for. Thomas, did you hear that video? The part that played?
I heard the video, yes, sir.
Okay. Is that your voice in the background?
That could be my son. We sound exactly alike.
It could be your son?
Yes, sir. His name is Dalton Thomas.
Okay. So you think that it could be your son. Do you recall this exchange in any way?
I do not.
You don't recall the exchange in
No,
any
sir.
way? Okay. I'll just play it through my client. As we sit here today, you have no proof saying that Scarlett is not being well taken care of in mother's home, correct?
That's correct.
Okay, you have no proof saying that she's not being able to provide for that child in terms of food and clothing and everything else, correct?
Correct.
And you haven't seen your child in a year, correct?
That's correct.
And are you asking this court to simply take that child away from mother at this time and place that child with you moving forward?
Yes, sir.
And you think that's in the child's best interest?
Yes, sir, I do.
Even though that child hasn't been with you for over a year and all of the things that have been going on here?
I think that is in the child's best interest. Yes, sir.
Okay, even though you agreed previously that she'd be able to relocate knowing she was pregnant at that point, right?
That's correct.
Okay. Nothing further right now, Your Honor.
I have a couple of questions. Mr. Kirby just asked you if you agreed to her relocating. I don't know that there's an order in the file here. I haven't been able to find it. Where did you agree to her relocating?
I was not exactly informed that I recall, sir, of where she was going. Just out of state is how it was labeled in the paperwork that was presented to me.
All right. When you and she married, if I understand correctly, you were married less than a year at the time she separated from you or she left. Is that correct?
Yes, sir.
During that time, did she work outside the home at all?
She never worked, no, sir.
All right. How did you and she meet?
She came into my business looking for countertops.
All right. And she lived here in this area at that time?
Yes, sir. She owned a house in Clarksville.
And when she came into your business looking for countertops, you and she met, obviously, and then you started dating, and then you married, and you were together for a year before you separated, correct?
Yes, sir.
And it's been a year since your separation.
Yes, sir.
Roughly.
September we separated.
September, it'll be a year this September.
Yes, sir.
All right. Now, are you living alone?
Yes, sir.
Okay. And we're talking about Scarlett. Scarlett is a child of how old? 1 year old?
Yes, sir.
So I have some experience with 1 year old children and grandchildren. Exactly how are you proposing to, I see the pictures of your home and it looks fine. How are you prepared to care for Scarlett if she were to come and stay with you?
Sure. I have a friend who is here to testify today that would testify to her ability to help me care for Scarlett.
This is a female friend that you have?
Yes, sir.
And is that somebody you're involved with as a person, as
No,
more than
sir.
a friend?
We are not more than friends, no,
All
sir.
right. And so you have someone lined up that would be able to help you if Scarlett were to come here?
Yes, sir. And have actually many. I have a church family who would also be more than willing to help me take care of Scarlett. Roberta is here. Her name is Roberta. She's here today to testify to her willingness to help me. And yes, sir.
And how many children does Mrs. Thomas have?
Currently, she has Connor, which is her 4-year-old. She has Dominic, her 13 to 14-year-old. She has Bria, her 15, about to be 16-year-old. So she has 3, and she has Scarlett, our child, together. So currently, she has 4 children living with her.
The youngest child that we're talking about that's an adoption, or has been put up for adoption by Ms. Thomas, that would be her 5th child?
Yes, sir.
Right. And how many children do you have?
I have 5 children that have grown up and moved out of the home, and they're out in the world doing their thing these days.
2 of those were your sons that work with you?
Yes, sir.
And those are the 2 sons that you're basically accusing of having a sexual relationship with your wife?
Yes, sir.
And how old are they?
The boys are 21 and 22 now, I think.
And I don't want you to tell me what it is, but you're saying you have some proof that that is in fact what has occurred?
Yes, sir. I have more than some proof. Yes, sir.
All right. Any questions based on what I've asked you? Thank you. Step down.
Nothing.
Step down. Gentlemen, Mr. Kirby, you have this final hearing. Who is that in front of?
This was set first, and I informed Chancellor Dean and opposing counsel there that I needed to come here to deal with this situation. But that was set on Chancellor Dean's docket for today because that is it's a final evidentiary hearing that's dealing with where is a child going to go to school starting up essentially next week, which is why he set it on that docket. Then Mr. Daniel Bryant's been nice enough to accommodate me this morning. He's the opposing counsel on that.
Would like to be heard today. Obviously, Judge, we've got witnesses here. Our last 3 witnesses, if the court needs to hear from them, are purely character witnesses, a pastor, support system, friends that have known Mr. Thomas for 7 years. And I'm not sure if the court needs that proof today, but they're here to say what kind of person he is. They've observed him at work. They've observed him. You know, the defendant in this case has alleged that Mr. Thomas is on drugs, has alleged Mr. Thomas is abusive, and he's got a slew of character witnesses here today to testify. They've known him for a long time and have never observed anything like that. They've never observed him lose his temper at work. They've never observed him be on drugs. They've observed him to be an upstanding member of the community. I'm not sure if the court needs to hear from Mr. Kirby wants to call his client. I would have a pretty brief, I think.
I think
we're asking to go forward today.
I think it would
What
be.
do you have tomorrow? You don't have anything now. What do you have tomorrow morning?
Let me grab my calendar here. I have one motion that I can have covered, and the rest are consults that I'll move.
I could be back tomorrow morning.
9 o'clock tomorrow morning, we'll resume this. I want to make sure everybody understands. I have to leave to go to a dental appointment in Franklin. I've got a crown that keeps coming off, and unless you want to have me proceed with a snaggle-tooth look, then I got to leave here a little before 2. So I would think that tomorrow morning in the 3 or 4 hours, we could conclude this matter. Both of you need to address the issue. Mr. Thomas, regardless of whether your client thinks he's a good husband or a bad husband or whatever, I understand your arguments about the alleged violence. He has a right to see his daughter, Scarlett, and that's all we're dealing with. So I want to be able to address under what circumstances each of you proposes that happen. As far as the immediate return of the child to the state of Tennessee, that's equivalent to, unless she moves back here, it's equivalent to granting him temporary custody, and that's a kind of a tall order considering where we are with everything. But I want to know what both of you propose for at least some sort of temporary visitation with him. He has the right to see his daughter, but it has been a year or so since he's seen this child, and a child of that age is going to be some adjustment that's going to be required. Normally, if they were living here together, I would be putting down an order of a graduated type of visitation. That doesn't appear to me not necessarily to be the case. In addition to that, we've got to work around this order of protection and whatever. So we're going to be looking at exchanges of the child, assuming that there is a visitation, exchanges of the child through third-party mediation or mediaries, so that there's no direct contact. The last thing I want is for Mr. Thomas to be in violation of his order of protection. When does that expire?
It's on appeal.
Yes.
So
Okay.
the previous council had reserved it for final hearing in this court. So
I think technically, and this is not what I'm necessarily suggesting, but I do think technically the court could amend the order of protection at this time because the fact that it is, I don't know that since it's on appeal, I'm not really sure about that.
If it's been more than a year since it was issued, even if it was on appeal, it's expired. I'll deal with it.
No, it's not been more than a year.
All right, then here's what I'm suggesting. We'll start at 9 o'clock. Both of you just keep in mind what my problem is. I want him to see this child. I want him to have contact with this child, and I want to protect the child from being traumatized by being around somebody that she may not be familiar with. But we've got to move in that direction, because unless there's some proof that he is unfit at all to have any custody or visitation with the child, he's going to get to see this child. So, and it may be graduated moving forward. One option is we just have the child brought back here and stay with him for a month, and then go back to the mom and stay for a month or a week at a time, something like that. They can then say that for the purposes of giving you an understanding that I take seriously his right to see the child, even if there are these issues that occur between them.
Thank you, Judge.
So be prepared to address that tomorrow.
Understood.
All right, we'll deal with the economic issues as well, and obviously I'll need to hear from her regarding her economic situation as well. So the court is going to be considering the fact that the obligation that Mr. Thomas has is for the support of his child, and that will be based on the child support guidelines. His support for her is based on whether or not there's an alimony or spousal support issue. That, as you all know, goes to the factors that are set forth in the statute, which include the length of the marriage that the parties have. We've got a 1-year marriage, so keep that in mind when we talk about tomorrow. All right, I will see you all at 9 o'clock She will need a Zoom link. Let me look and see if I can just give one right quick. That will work. I need to change it. See, here, I was supposed to be in Cheatham County, so my Zoom link was for Cheatham County. That's why it's showing up as Cheatham County. Tomorrow, I was supposed to hear a Humphreys County case, but we'll do that with the same Zoom link. Give them that Zoom link. So.
We're still coming here, though, correct?
You are coming here.
Okay. I just want to make sure I didn't drive to Humphreys
No,
County when I would
no.
need to be in Dixon.
All right, hold on. I'm going to change, that's for 30, so I'm going to edit that so that it'll show what it's actually supposed to be.
And I apologize about the scheduling of today, Your Honor. This got put on my calendar.
You tell Chancellor Dean that I am deferring to him only because I like him and I like him and that he's a fan of our YouTube channel, so he might learn something, so.
I will make sure to start off my opening that way because maybe it'll get me some brownie points.
Sounds good to me. Thank you.
Thank you, Judge. Thank you very much, Your Honor. Ms. Thomas, I've got the other hearing, but I will call you when I get done with that because I'm going to go straight into that hearing, okay?
Okay.
Thank you. Thank you, Your Honor.
All right. All right, everybody ready? We're back on Thomas versus Thomas. So I believe at this point we need to, you were putting on your proof, correct? All right. Go ahead. Call your next witness. You're calling Rachel Thomas. Ms. Thomas, you're being called as an adverse witness. You need to raise your right hand and let me place you under oath, please. Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you.
Ms. Thomas, my name is Nicholas Bellamy. I represent Michael Thomas in this matter. I've got a few questions for you this morning, okay?
Okay.
Are you able to hear me okay?
Yes, sir.
If you can't hear me at any time, just please speak up and let us know, okay?
Okay.
Ms. Thomas, do you recall filing an income and expense affidavit in November of 2025?
Yes.
Okay. Are you able to locate that income and expense affidavit? Are you able to get a copy in front of you, or do you recall what that affidavit says?
I don't have the ability to get it in front of me, but if you could show it to me, I would be more than willing to look at it.
Okay. I don't know that I'll be able to show it to you this morning, but I can kind of walk you through it. So in your income and expense statement, you'd swore that your income was $3,314 per month. Is that correct?
Yes.
Okay. And is that still your income monthly?
Yes, that's my child support.
Okay. And so when you say your child support, is that for one child or for more than one child?
That's for more than one child.
Okay. So how many individuals are currently paying you child support?
2.
Were you previously married to those 2 individuals?
Just the first one, my 2 older kids' father.
So how much what is his name?
His name is Louis Lovejoy.
Louis Lovejoy. How much does Mr. Lovejoy pay you per month?
$2,050.
Okay. And then who else pays you child support?
Mario Ramos Tomasini.
Okay. And how much child support does he pay per month?
$1,260.
And then you have received $1,500 a month for Mr. Thomas since the court's entry of that temporary support order, correct?
Correct.
And in addition to that, Mr. Thomas is paying for the Ford Expedition, is that correct?
Yes.
And the Ford Expedition costs approximately $1,300 a month, is that
Yes.
correct? And he's also paying for the car insurance for that vehicle, is that correct?
Yes.
Is Mr. Thomas currently paying any other of your expenses?
No.
And so on this income and expense affidavit, you swore that you were paying $2,000 a month for food, is that correct?
Yes.
And an additional $1,000 a month for eating out.
Yes.
So it's your testimony before this court, you pay $3,000 a month for food.
Yes.
And that's for you and how many children?
That's for me and my parents and my children because I live within their home.
So you pay for your parents' food as well.
Yes.
Okay. So how much of that $3,000 per month goes towards your parents?
Oh gosh. I don't know because I do like when I go grocery shopping, it's boxed. So I mean, I wouldn't know how to break that down to how much they get a month for the food part.
And your parents don't provide you any money for the food?
No.
Are you paying your parents rent to live in their home?
So I give them money when I can. So sometimes it's 400, sometimes it's just when uh Michael started paying me the 1,500, I started giving them money back because they were helping support me during the time that that he was not.
And you swore that you were paying $1,000 a month in breast milk, is that correct?
Yes.
And are you still paying $1,000 per month for breast milk?
No, sir.
So that expense is completely gone.
Yes.
Hygiene, diapers, and wipes. Are you paying $220 a month for diapers, wipes, and hygiene products still?
Yes.
And you swore on your income and expense affidavit that you were paying $640 a month for fuel. Is that accurate?
Not anymore. No, sir.
Because you have there written out in the parentheses that you fill up twice a week at $80 each time. Are you still doing that?
No, sir.
So how much are you spending a month on fuel now?
Maybe roughly 400.
Are you currently working anywhere?
No,
Okay. Are you going to school?
I am full time.
Okay. When did you enroll in school?
January of this year.
And what are you going to school for?
Uh, well, my end goal is to go to law school, but I graduate next summer with a bachelor's degree in business administration.
How are you paying for school?
It is through the student loans.
How much student loans are you receiving? Is it a monthly basis? Is it a semester basis?
I don't know if it's like unsubsidized or I don't, but it's through the government, and they send the funds directly to the school.
Do you receive any other benefits going to school?
No,
Are you on food stamps?
no,
You have government health insurance.
yes,
Okay. Is that for you and the children that you are currently in your home?
uh, just for me and Scarlett.
And on your income and expense affidavit, you had swore that you were spending $130 a month on burn boot camp. Do you still have that expense?
No, sir.
The $11 at Chuck E. Cheese monthly,
No, sir.
the $400 a month for your beauty care.
So I usually get my hair done every 6 weeks, and I would say that's 250 every 6 weeks is what I usually spend on my hair.
So not $400 a month.
That's correct.
$200 a month on family outings.
I would say that's accurate.
Before you went to school, did you hold employment?
No, sir.
When's the last time you were employed?
My last official job was I think when I was 16 when I worked for Wendy's, and then I worked for a short period of time at a urgent care when I was 18. And then when I lived in Texas, I walked dogs on the side and watched them. And that's it. And then I worked for the company a lot when I was with Michael. I worked with the business and meeting up with clients.
Did you receive a paycheck there?
No, sir.
And is your testimony you started school in January, but you'll graduate with a bachelor's degree. So do you currently hold an associate's degree already?
No, sir.
Okay. So when did you start school?
Um, Back in 2000 and I started my sophomore year of high school taking dual college courses. And so when I graduated high school, I had like 21 credit hours through Marshall University. And then I had ongoing for a couple on and off semesters in my earlier 20s, and that's how I accumulated hours. I was at the time going for my teaching degree and quit that due to marriage and kids, and now I'm resuming a degree in business.
So you picked up school this past January. already had more than half of your credit hours necessary for the bachelor's degree. Is that fair to say?
Yes.
You and Mr. Thomas were married approximately April 15th, 2024. Is that correct?
April 13th, I believe. Yes, sir.
13th, 2024. And you separated in September of 2025. Is that correct?
Yes.
So it's fair to say that you were together as a married couple for approximately 17 months?
Yes, sir.
When was baby Thomas born?
March 17th of 2025.
And at what time did you start seeking an adoption?
I started looking into it about 2 months after, well, I found out I was pregnant 2 months after giving birth to Scarlett. And right away, I started looking into it.
When did you make contact with the adoption agency that you're currently going through?
I would probably say around that time, if I recall correctly.
So it's your testimony that from the beginning of finding out you were pregnant with baby Thomas, that it was your plan to adopt her out. Is that correct?
That's correct.
Do you recall filing a motion in this court on May 6th of 2026, asking the court to increase spousal support and child support due to the birth of baby Thomas?
Yes.
Okay. And in that motion, I know you don't have it in front of you, but you stated that you had given birth to the husband's second child and your expenses have increased. Is that correct?
My lawyer, my previous counsel, had submitted that and then canceled it out because he was unaware that I was going to completely go through with the adoption. And when he had submitted that with the courts, he retracted it because of that.
So
That's
your
why
lawyer
it was.
didn't know that you were going through with the adoption. Is that correct?
That's correct.
And this court didn't know that you were going through with the adoption. Is that correct?
That's correct.
You might have mentioned it to Mr. Thomas, but you never confirmed with Mr. Thomas that you were going through with the adoption. Is that correct?
He would have known that I was going to go through with it because I told him I was going through with it.
And when was that?
I don't know. It was roughly after I got pregnant because we were referring to his friends at first as a possibility to adopt her. And then after that, then they did not want to adopt her. They were almost an empty nester, and that was just out of the question for the wife at the time. And that's when I started seeking Christian adoption agencies to find a couple that could care for her.
And that was all prior to September of 2025, your contact with Mr. Thomas, correct?
Yes.
And after September of 2025, you don't communicate this to Mr. Thomas whatsoever. Is that correct?
Yep, I had a protective order.
And you know under that protection order, you can communicate with him, he just can't communicate with you. You understand that, correct?
Objection, calling for a legal conclusion.
I've sustained it unless the language is produced for her to examine and make a determination of what she understood it to be. So
I'll strike it.
let me say this. I will allow the question to be re-asked in a different format, but sustain it as to its present form. It's really what she understood that really matters, I guess.
Sure. Did you understand you could communicate with Mr. Thomas?
No,
You ever ask your attorney if you could communicate with him?
Objection, call.
no,
Sustain the objection.
I'll strike it, Judge. But you never informed Mr. Thomas, you never talked to him after September of 2025, correct?
that's correct.
And I know you don't have it in front of me, but did you understand that when this divorce was filed, a statutory injunction went into effect?
Yes.
Okay. And you understand that that statutory injunction prohibits you from doing certain things without the approval, permission from this court or an agreement of the parties. Do you understand
I
that?
can't, yes, but I can't recall exactly everything that was located in that injunction.
And if that injunction, I'll read the relevant portion I'm referring to. There was an injunction filed in this court that states there's an injunction restraining both parties from relocating any children of the parties outside the state of Tennessee or more than 50 miles from the marital home without the permission of the other party or an order of the court, except in the case of a removal based upon a well-founded fear of physical abuse against either the fleeing parent or the child. In such cases, upon request of the non-relocating parent, the court will conduct an expedited hearing by phone conferences, if appropriate, to determine the reasonableness of the relocation and to make such other orders appropriate. Did you understand that that was in effect during this
Yes.
divorce?
Yes, sir.
Relevance at this point, we've got an agreed order that was entered that me and opposing counsel has already talked about being entered as saying that she can relocate out of state to an undisclosed location because of the reasonable fear that she had of domestic violence within the.
When you make an objection, turn that on for that.
I thought it was on. I apologize. Oh,
Okay, as long as it's being picked up, because the reason I say that is your client cannot hear you unless that microphone is on.
Ms. Thomas, did you hear the objection or do you need me to repeat it?
I heard it.
All right.
Judge,
So
I would respond as follows. It's
may.
absolutely relevant. The agreed order allowed Ms. Thomas to relocate with Scarlett to an undisclosed location, but it did not permit her to take baby Thomas and move her to Colorado without informing anybody, her attorney, this court, or Mr. Thomas. So it's absolutely relevant. She's violated the statutory injunction.
Overrule the objection. I believe that the statutory injunction and the agreed order would have covered Mrs. Thomas and Scarlett. Baby Thomas, as we're referring to that child, was not a life in being, I suppose, at the point in time when that order went down, and as a result, that order could not have applied to her. As I think counsel has pointed out, the question becomes then whether or not that's a violation of the statutory injunction for her to ship that child off to Colorado.
And Ms. Thomas, do you recall responding to interrogatories in this case? You filled out a packet of questions. Ms. Thomas, I know you don't have these in front of you, but I would direct your attention to question number 31. It asked, please state the specific days and times that you propose the husband have parenting time with the minor children, and attach hereto as a request for production your proposed permanent parenting plan in this matter. Do you recall what your response was to that interrogatory?
I do not.
Okay. If it was 0 out of 365, would that be an accurate response?
Yes.
Okay. So you propose Mr. Thomas have no parenting time whatsoever, is that correct?
At that time, due to his behavior and what was going on within the relationship for the safety of our child, absolutely.
So it was your goal at that time to cut him out of the children's lives completely. Is that fair to say?
Not forever, sir, not if he got better.
And are you aware that since the events that occurred between you and Mr. Thomas, since he was charged criminally and entered that no contest plea, he has not been charged with any new criminal charges? Are you aware of that?
Can you restate that once again?
Since the events occurred between you and Mr. Thomas that led to him being charged with or pleading no contest to a simple assault and to a violation of a protective order, he has not been charged or arrested for any new offenses?
No, sir. He has not been.
Are you aware if he's violated his probation that he's on?
I wouldn't know that information, sir.
So as you sit here today, you have no new information from September 2025 to current with respect to Mr. Thomas.
I do, sir.
Okay, and what is that?
He got arrested back in Georgia in the month of February for speeding, going 101, I believe, in a 70-mile-per-hour zone. And that was when they arrested him. They found out that he had an active arrest warrant in the county of York in South Carolina. They extradited him after he spent, I think it was 8 days in jail down in Georgia. They extradited him for a felony assault charge against a woman that I'm unaware of who she is. And he served there until he was, I believe he bonded out or whatever the term is with that. And that was for aggravated assault in the second degree. He was also arrested for, from you said, from the events of September to current. He was arrested for a violation of the protective order when my daughter and I had an appointment to go to in Nashville. He took my vehicle out of the parking garage, at which the detective that was on the case at the time had gotten video surveillance of him taking my vehicle after I had arrived there to leave me stranded there with no vehicle. Metro PD put a bolo out for the vehicle, and he got arrested in Montgomery County for taking the vehicle. And I believed at that time, I could be inaccurate, but I believe that's when they arrested him for the domestic assault and the violation of the protective order. There was also another arrest for violation of his, I think it's restriction of his bond. Trying to recall some more things.
And so that was all around that the violation of the protection order that he was arrested for and entered a no contest plea to. That was on or around that September 2025 timeframe. Is that correct?
I think the majority of the violations, because there was multiple times that the police were called out to the property. I think a lot of it was done in October, the month of October, I believe.
And then the other incidents you mentioned, the speeding, the warrant for his arrest in, I believe you said Georgia. Do you know when those violations occurred?
February 8th, I think, is when he got arrested in Georgia.
Not my question, ma'am. I'm asking, do you know when those violations occurred? When he allegedly broke the law in those states?
If you can give me a minute, I can pull it up if
I'm asking, do
you want
you
me to
have
give you exact dates.
when those were?
I'm sorry, can you repeat yourself again?
Thomas, I'm asking if you have personal knowledge as you sit here right now, not without looking at anything. I'm asking if you have personal knowledge of when those violations allegedly occurred.
February 8th was when he got arrested,
Thomas,
best to my recollection. And February 16th was when he got extradited to South Carolina.
I request the court direct her to answer my question. I'm not asking when he was
Ms.
arrested.
Thomas, you need to listen to what he's asking. He's asking you if you know, when is it alleged that he actually violated the law that led to those warrants being arrested? Not when he was picked up, but when,
Oh,
how old were the charges is I think what is being
uh,
asked. If you know. If you don't know, that's okay.
I want to say April 17. I just can't recollect the day.
Well, rather than look at something that we can't see, you just need to answer from your memory. If you have
That's
memory of how,
that's my memory, sir, is April of 2017.
April of 2017.
Yes.
That was before you met Mr. Thomas, is that correct?
Yes,
That's
sir.
before you had children with Mr. Thomas, is that correct?
The video cut off. I'm sorry. What was that?
Okay. That was before you had children with Mr. Thomas, is that correct?
The April 2017. Yeah, because we were not together, sir.
The adoptive parents in Colorado, do you know who they are?
Yes, sir.
Do you have a personal relationship with them?
Yes, sir.
Do you know who they were prior to the adoption placement?
No, sir.
So did you meet them through the adoption agency?
Yes, sir.
Let's make clear, those are potential adoptive parents. This court is of the opinion, and I have ruled that this court has jurisdiction over the custody of that baby Thomas, and that in this court's opinion, that Colorado does not have the authority to grant an adoption. So when we refer to those folks out there in Colorado, they are potential adoptive parents. They are not adoptive parents.
Thank you, Judge.
I'd also, at this point, I know we're going down this line of questioning. I'm just going to.
Is your microphone on?
It
still?
is, Your Honor.
Okay.
I'm just going to, thank you.
Yes, that's right. I just wanted, you can pull it there closer so that Ms. Thomas can hear you. So.
I also might be just height-wise too far away from it, but when it comes to that, I'm just going to object to the relevance of what we have going on here. The court's already entered a stay as far as the issues of that child that's going through the adoption. I think it's well established at this point that adoption proceeding is going on, but in terms of what we have here today, I don't think that it has any relevance.
Let me make clear one thing. This court today is considering what sort of parenting plan that I should put down in this case. And there's no question, the parties have conceded that I have the right to make a parenting plan for Scarlett Thomas, who is the biological child of these two parents. I have deferred to an interlocutory appeal on the question of jurisdiction to avoid any kind of long-term issues, but I fully expect the Court of Civil Appeals is going to affirm what I have ruled as far as the jurisdiction. I may be wrong. But in this case, we all know what the statutory factors are, and the statutory factors are that I have to consider who should be the primary residential parent, and that's what I'm going to be doing today. And part of those factors are going to be what kind of relationship each of them has with the child that I'm going to be entering an order on, and whether one of the parents has encouraged a healthy relationship with the other parent. And the fact that Ms. Thomas, for whatever reason, is willing to give up a newborn infant, a child of Mr. Thomas's, to some other third parties for adoption is in fact a factor that this court will consider in weighing those statutory factors regarding Scarlett's custody. So I overrule your objection. I think it's highly relevant, and you will be allowed to ask all the questions that you like.
Thank you, Judge. Ms. Thomas, we haven't seen any of these documents. These documents haven't been produced to us yet, but you are currently in the state of Virginia or West Virginia?
West Virginia.
West Virginia. And in West Virginia, you engaged in what's called an ICPC process. Is that correct?
Yes, sir.
Okay. And in that ICPC process, did you have to identify who baby Thomas's father was?
Yes, sir.
Did you identify who baby Thomas's
Yes,
father
sir.
was? Okay. Did you provide baby Thomas's father's contact information during that ICPC process?
Yes, to the lawyer at the time in West Virginia, I did.
Okay. Did you ever direct that lawyer to contact Mr. Thomas?
Attorney-client privilege again at this point.
I don't think she can be asked about communication she had with her former lawyer, so sustain the objection.
So it's your testimony, you identified Mr. Thomas as the father during that ICPC process.
Yes, sir.
Did you make any reasonable efforts to notify Mr. Thomas about that process?
There was a protection order in place.
And so it's your basis you didn't notify Mr. Thomas due to the protection order.
So that the record is clear, do you want to define what the ICPC is that you're referring to?
It's the Interstate Compact on the Placement of Children. And that's the process you engaged in when you sent the child from West Virginia to Colorado. And so
Yes.
it's your testimony as it sits here today that you did not notify Mr. Thomas of that process due to the protective order that was in place.
Yes. And there was also a lawyer that was hired on my behalf from the couple that was paid to represent and handle the legal proceedings involving anything that had to do with the father. I am not sure what those legalities are in regards to what they do when it comes to notifying the father or mother at any given case. I followed the instructions and I did whatever the adoption lawyer had asked me to comply with.
So you're receiving money from these potential adoptive parents.
I have not received money from the potential parents.
They've paid your attorney's fees, though.
They have to pay for the fees associated with the attorneys to be representing on my behalf in West Virginia.
Have they paid your attorney's fees here in Tennessee?
No, no, sir.
But they paid your attorneys in West Virginia.
The one that's representing the adoption to help the ICPC to be complied with Colorado. Yes, sir.
Do you know how much they paid that attorney?
I can't give you an amount. I truly don't know.
Ms. Thomas, what is your current school schedule?
So I, as soon as the kids go to bed at night, I usually stay up roughly around probably 9 o'clock, depending on what time the kids get into bed, until midnight to 1 o'clock every morning, sir.
Your classes are between midnight and 1 o'clock every morning?
I can do the scheduling whenever I want, and my time is I do it so I don't take away from the kids during the day. Is whenever they get to bed, that's when I get my schoolwork done.
So your schoolwork is done fully remote?
That's correct.
You don't attend any in-person classes?
That's correct.
And how many credit hours are you currently enrolled in?
Oh, I'm full time. But the way it's broken up is that it's so every 6 weeks we get 2 new classes, and but it's year round. So like I'm going like right now in the summertime. So it's not traditional where you get like four classes to the semester and you get the 12 hours by the time summer hits. It's you get 2 classes every 6 weeks and they just renew till I graduate.
Do you have any childcare expenses?
No, sir.
Do you have any childcare expenses?
No, sir.
So who watches the children if you were to leave the house? Do your parents provide childcare for you?
Yeah. Yes, sir.
And how often do you leave the house? How often do they provide childcare?
Seldomly ever. I'm with the kids 24/7 usually. I mean, if I have to go to the store and on a grocery run, they'll keep them while I go on a grocery run so I don't have to drag 4 kids out of the house. But for any extended length of time, unless it's I don't know, like when I was with Michael, they took Scarlett for a week and gave him and me some time together after she was born, but outside of like a grocery trip here or there, they don't keep them.
And Scarlett was approximately 7 months old when you relocated, is that correct?
Yes, about 7 months old.
And during those 7 months, did Mr. Thomas interact with Scarlett?
Yes, sir.
Did he help feed her?
Yes.
Did he help change her diapers?
No.
Did he provide for her?
Well, I provided the milk and that's what she drank.
Okay. Who bought the clothes?
Michael did.
Who bought the cribs, the baby furniture, the car seats?
Michael did.
Judge, if I may just have one
You
moment.
may. Mr. Kirby, you may examine your client.
Thank you very much, Your Honor. Morning, Ms. Thomas. Can you hear me okay?
Yes, sir.
Perfect. I'm going to ask you a few questions. Again, I'll reiterate what Mr. Bellamy said, which is if you can't hear me, don't understand me, it cuts out, just let me know, okay?
Okay.
All right, so you relocated to West Virginia after there was an order of protection filed. Is that right?
Yes, sir.
Okay. And there was an agreed order that was also entered. Is that your understanding?
Yes, sir.
And that agreed order read that through the final hearing of the divorce, the wife and minor child are allowed to relocate out of the state of Tennessee to an undisclosed location of wife's choosing due to a well-founded fear of physical abuse against the wife and minor child, correct?
Yes.
And it also stated that the parties have agreed to extend the existing order of protection and reserve the hearing on the appeal to be heard in conjunction with the final hearing of the divorce in this matter. Is that correct?
Yes.
And this is also what allowed Mr. Thomas to return to the marital residence at 1790 Cedar Creek Road, Van Leer, Tennessee. Is that correct?
Yes, sir.
And that was signed off on by this court on November 3rd of 2025. And shortly after that, you relocated to where you are now. Is that a fair statement?
Yes, sir.
Now, I want to talk about where Mr. Bellamy left off, okay?
Okay.
You weren't employed during...
Thank you for watching. We hope you found this video informative and engaging. If you enjoyed the content, make sure to like, subscribe, and turn on notifications so you never miss our latest videos. Your support helps us continue bringing you more insightful and compelling content. Thanks for watching, and we'll see you in the next video.